Welcome back for another episode of SSD Mythbusters, where each episode we tackle a myth in the world of Social Security disability law by asking our disability attorney Josh Worley and letting him give us the facts that we need to know to prove whether it's true or busted, and try and give as much information as we can. Josh, welcome.
Thank you. Thanks.
All right. Today's myth is all about the hearings. We hear a lot about hearings. So the myth is hearings are like the trials that I see on TV. And we got a lot of episodes like Law and Order, The Practice. Oh man, we may show our age a little bit if I give too many.
And well, a lot of ways in the past.
You know, my wife hates watching those shows with me because as a lawyer, it just gets all over me. I'm saying, this is not real life. What is it like? What are these Social Security hearings like?
Okay, so this myth is definitely busted. The Social Security hearings that we have are nothing like what you see on TV. And of course, you know, when people know that they have a hearing coming up, or even if they hear that a hearing is a part of this process potentially at some point, that's pretty intimidating, and people get pretty worried about that. The reality is that a Social Security hearing is a very informal hearing that is really not a intimidating, scary thing to go through. Most of the hearings now are either done by video, so by basically like a Zoom video hearing, or a lot of them are also over the phone. So if they're over the phone, then you can be in the comfort of your own home and you're on a three-way call with your attorney and the judge, and there's actually another expert that's on the line. But it's just a phone call where you're talking to the judge. And in the video, similar type of thing. You obviously can be at home and either on your computer or you're on your phone, and so there's something to be said about being able to be in the comfort of a familiar environment in those situations. There are some live hearings that still take place, but I would say that's the exception, not the rule. Doesn't happen too often.
Okay. You know, I think a lot of people see these courtrooms, whether it's on TV or otherwise, and you have a judge and there's sometimes multiple attorneys. Set the scene for someone who participates in these hearings.
So really, the majority of the hearing is the client or the claimant, the judge, and the attorney speaking. And the main objective in the hearing is to tell the story for the claimant. What's going on in their life? What's going on health-wise that prevents them from being able to work? So I tell my clients all the time, the better we tell your story and the better we put the judge in your shoes for a little bit of time, for that 1 hour of time. The hearings are typically about an hour long. The better we can put the judge in your shoes for that period of time and help explain to him all the day-to-day things that are going on, then the better our chances are of being successful. It's not we don't commonly get bogged down in really technical medical terms in the hearing because the judge can review the medical records. The judge can see all the technical stuff in the medical records typically. So this hearing is just a chance to talk directly to the decision maker. And so really the majority of it is either the judge asking questions of the claimant, or if you've got an attorney, the attorney asking questions of the claimant to get their story told.
So there's not opposing counsel. There's not an attorney on the other side looking to disprove them or anything like that. That if anything, that's the role of the judge to get more information. But there's not opposing counsel to them.
That's exactly right. There is no one there working against you in your case, trying to prove that you are not disabled. No, absolutely not. It is just it's really a fact-finding hearing to give the judge information.
And in most situations, you guys have, for instance, if you're representing someone, you've presented all of the medical records. The judge, in theory, has reviewed all of that and is coming into the hearing having read all that and may just have some questions in addition to what you may present or the client may say. Is that right?
That is exactly right. A judge, and one of the things that we do in our office as an attorney, we work really hard to make sure that we have collected all of the medical records and submitted them in advance of the hearing. There's a 5-day rule where you have to have all the records in 5 days prior to the hearing, just so the judge has a chance to review all those records and see everything, see all that before the hearing ever starts. So when you start that hearing, the judge will know all about the claimant. The judge will know what all the records say. And really, when you get into a hearing, yeah, it's pretty common where a judge will say, okay, Mr. Smith, I saw in your record that it says that, this is going on. Can you tell me a little bit more about this? How often does this happen? So a lot of times the hearing is just a chance to provide clarity, more information in addition to what they've seen in the records.
And for someone that may be intimidated by that process, that's another benefit of having someone like an attorney that can be kind of an advocate and can strategically kind of pull out some of that information that may be most beneficial to the claimant. Because you may have thousands of pages of medical records, and you're able to help question them in a way that walks them through highlighting the strengths of their case.
Certainly that is the case, yes. I mean, a couple significant things that we're doing as we lead up to a hearing. I mentioned that we get all the medical records. It's a huge part of what we do. It's a lot of work because someone that's a claimant that's filing for disability commonly has lots of records out there. So yes, we collect all those records, we get all those submitted. We then, before the hearing, will meet with our client, talk to them about, okay, these are the things that we're seeing in the records, this is what we're claiming, but let's talk about how it best presents to the judge. How do you address these questions that come up, that are going to come up in the hearing? And we help our clients just get prepared so that they're ready to tell their story in a way that gives them the best chance of getting approved. I always tell my clients, we absolutely have to tell the truth. That is a huge part of what's going on in the hearing is your credibility. The judge is listening to what you're saying. And if the judge believes you and finds you credible, then that's a big part of getting approved. So we talk all through all those kinds of things. But yes, and then in the hearing itself, when you have an attorney, the attorney can lead you through your testimony and lead you through all of the questions that need to be asked, where if you don't have an attorney, then basically it's kind of left up to the judge to ask the questions, and I don't think you get your story across like you do if you've got a seasoned attorney that knows what they're doing in these situations.
Well, there we have it. So not like TV courtrooms. In fact, we've learned it's really this kind of an administrative law process that's a lot more informal, less intimidating, wouldn't you say?
Yes.
Okay, so clients that have been through this process, I think, find it less intimidating than they might otherwise have thought going in. Just your attorney, a judge, and you giving testimony. And so it's really not as intimidating of a process as one might think. So hopefully this has been helpful for you to get a little bit more of an idea about what a Social Security hearing is like. Give us a follow. We're going to keep talking about a lot of these topics. Also, if you find yourself thinking, I would like more information, you can reach out to us at the Injury and Disability Law Center. Josh handles and our Social Security team handles cases all over the country. We'd be happy to visit with you, see if we can help you. So until next time, Josh, thanks. We'll see you next time.